And good day, everyone. Richard Cowperthwait for Northwest Access TV. Thanks for joining us as we get ever closer to the August 14th primary election in Vermont. Happy to have the two candidates for Franklin County probate judge. Bob Farrar, as I look out on my right, Vaughn Comeau on my left. Bob, an attorney in St. Albans, Vaughn, an attorney in Enosburg. Thanks for the time, folks.
No problem, glad to be here.
So I guess my first question, again, we were just talking off air about the primary coming up on August 14th. Does anyone, you folks have been campaigning for a while, Bob, how many folks are even aware that there's a primary election and even know what it is? Is that kind of discouraging as you go out on the campaign trail?
I think initially they're not too aware of it, but if you talk to the folks and tell them about it and how important it is, then I think most folks will either get an absentee ballot or go to the polls on that day. Yeah. And because there's quite a few other races too. There's a sheriff candidate Langevin is very active on the Democratic side, and sheriff candidate Oliver is very active on the Republican side.
Although that's not a primary contest, but you're right. That's kind of maybe the marquee race in Franklin County. But
right, but they're both very active about it.
So. And I'm sure they're looking to get their supporters out. Vaughn, again, is it a little discouraging out there to people? How many people are even aware of the upcoming primary?
Not a lot of people. The one advantage I think we have now is with this extended voting. And people being able to vote at their convenience. So we've been trying to get the message out that if you're around the town clerk's office and planning to be out of town, you don't have to get an absentee ballot anymore. Just pop in and vote anytime between now and August 14th.
So. Good point. I should know we're taping this show on Tuesday, July 24th, and as the candidates have said, voting. As soon as you see us on air, from today, and voting's been going on for a while. So, or in fact, I was at St. Albans City Hall today, and folks, Curry and Susan said, X number of people have voted, so there's some people who are already doing that. So, voting is underway. How about some background? Bob, we'll start with yourself. And you've taken a shot at probate judge in the past, as I recall.
I ran in the Democratic primary in 2006, and Larry Bruce was the other candidate, and he prevailed, and he went on to win two additional terms besides that one.
Right. And of course, worth noting, he's of course retiring.
Yes, he's retiring.
Going for it.
And when he and I were campaigning then in 2006, and he said, if I win, I will not practice in my private practice anymore. I'll be full-time. And of course, he kept that promise, and he became, for all practical purposes, a full-time probate court judge. I did not make that promise that time, but I am now, it's part of my campaign slogan, if you will, that I would become a full-time judge if I were to be so fortunate to prevail. I would not have a private practice any longer.
Just to be clear, I hear what you're saying. When you say you'd be a full-time judge, meaning you wouldn't be doing any private practice.
That is correct.
For the record, the probate judgeship in Franklin County is officially a part-time position, though.
It doesn't say it in so many words, but the statute does say the Chittenden County probate judge shall be a full-time position. Okay. And so it is not considered a full-time position in the statute. For example, Attorney Ned Spear,
in Grand Isle County,
in Swanton, is also the probate judge in Grand Isle County. So he doesn't do it full-time. Of course, Grand Isle County is not as busy as Franklin County, but I feel that Franklin County is getting busier and busier, so it could use a full-time judge. That's my opinion.
Okay.
But that's not my background. That's one part of my background. The rest of my background, if you want me to go forward a little bit, is
a couple of minutes.
I'm a U.S. Army veteran. Then after following that, I went to Boston University Law School. I previously had graduated from Syracuse University. And after the law school, I moved to Vermont with my wife, Susan, and we've been here ever since. And I started working as an assistant state's attorney and later became a public defender. And eventually went into private practice. I was in private practice solo, and after a while I went in with Bill Kunis. We were partners for 6 or 7 years, I think. And I was also a partner with who is now Judge Rainville, for a couple of years. And other than that, I've been in solo practice for many years. And I've had a variety of experiences in all the different courts in Franklin County and elsewhere, family court and the civil division of Superior Court, It's not called family court anymore, but it used to be called family court. Now it's just family division, criminal division, environmental division, and probate division. I've had experience in all of those, so I think I'm qualified in that regard.
Logged some time also as St. Albans City Attorney. I forget if you mentioned that.
I was city attorney for quite a few years, primarily when Bill Chiaffi, who is now deceased, our great city manager at that time. And as you may know, as city attorney, you do all kinds of work representing the council and the different boards and litigation and contracts. So I had a wealth of experience in that time as well.
Okay.
And like I say, we still live here in Franklin County. We lived in St. Albans for 34 years in the same house, I think. And my two children are now grown. Caitlin is a teacher in St. Albans Town at SOAR. And my son Sam is a sales manager up at a local dealership, car dealership. So we've got our roots right here in Franklin County, and I'd like to continue to serve the people of Franklin County, if they'll have me.
Okay, fine. Tell us about yourself.
I grew up in Swanton, graduated from MBU. My dad's a PhD chemist and instrumental chemist, and my mom was one of the first female priests ordained in the Episcopal Church. Graduated from MVU, went to Kenyon College, and came back to Vermont. My first career was as an environmental chemist. Graduated with an international studies degree and a chemistry degree, double major. And company bought the firm I was working at in Colchester and moved me over to England to work in the former Soviet Union. I had a Russian concentration, was Soviet studies at the time. Spent my junior year abroad there, and so I went back and forth working on World Bank contracts for 3 years, and then they moved me to Reno, Nevada for 6 weeks, and then Uzbekistan for 15 months, then Miami for almost 3 years, and then finally to Baltimore. At that point, I decided I'd move 5 times in 7 years, and it was time to do something else, and I decided to go to law school. So went to law school and graduated from there. I got a federal judicial clerkship during my 3rd year of law school, and I don't think anybody's ever had that while they're still studying for the bar. But I did that after during the 3rd year of law school and graduated. Did that and went to McGuire Woods, which is a large law firm based out of Richmond, and was an associate there for almost 5 years. And the opportunity came, practice opened up in Enosburg, and I wanted to come back.
Doug DeVries' old practice?
Yep, and Ned and Don Pellman tried to run it part-time for a while, and Ned called up and said, we've got to practice, we're not able to do this, do you want to come back to Vermont? And it was a good opportunity for my wife and I to come back, and built a thriving practice, mostly probate, real estate, some civil work, but focus on probate, estate planning, some municipal work, and that's what we've built up over the last 6 years.
Interesting. And again, if you were elected probate judge, you would continue your practice. Obviously, there'd be some probate matters you couldn't deal with, but you'd continue your private practice.
Right. 13 out of the 14 probate judges in Vermont
That's not unusual, I guess.
Are part-time practices,
Okay.
And I think 9 out of the 14 maintain a private practice. Northern Vermont is so underserved in terms of legal services, and I've actually had people tell me they will not vote for me if I close my practice, because it's such a vital part of the community and the services that they give. I'm very efficient in my practice. I've built it up to where I can pick and choose what I do and don't do, and I'm very flexible in my schedule as a solo practitioner. So while it's a part-time position and the Supreme Court bases that on the caseload, you're available and on call 24/7, and there are occasions when you have to accommodate hearings outside of the courtroom, emergency situations, and I'm perfectly positioned with my practice the way it is to be able to do that.
I should note, if I didn't already, you're both, of course, running as Democrats since the Democratic primary contest on August 14. I can only assume, I would assume, or certainly a possibility, that one of you will get enough Republican write-in votes to be the Republican nominee, again, via write-in votes. Bob, are you making any effort to get Republican write-in votes?
I'm not making any effort, but I do occasionally mention it to my Republican friends that if they go and get a Republican ballot, I invite them to write me in. And so I don't know whether they will or not, but if people feel comfortable voting for me in any capacity, I'm open to that concept.
So you'd be happy to get the Republican nomination if that happened on write-ins?
I think something similar happened to Dave Miller once when he was running for Grand Isle State's Attorney.
You're right.
And I don't remember who his opponent was, but I think it was a female, and she won the Democratic primary.
Yeah.
But Dave got some write-in votes as a Republican and went on to contest the election as a Republican.
And in fact, you're right on. That's exactly what happened. I think David got just enough write-in votes to win the Republican nomination and ended up winning the election.
I think he did.
Yeah. Vaughn, what about yourself? Are you making an effort to get Republican write-ins?
Not really. I think as any election and any participation in the democracy, I think it's important to get people out to vote. My personal feeling is this position should not be subject to a partisan primary. There are independent candidates, independent positions that are voted without primary affiliation.
Meaning you think you shouldn't have to run with a party affiliation?
I don't think so, and of course, as a member of the judiciary, your party affiliation has no meaning on your interpretation or administration of the law. It's just an artifact of our system that we have to run.
For that matter, do you think this should be an elected position? Does it just make sense to?
It's in the Constitution of the state of Vermont that probate judges are elected, sheriffs are elected. But I agree with Vaughn in the idea that it's kind of an anomaly for judges to say they're a Democrat or a Republican, which obviously we've done, but it seems a little contrary to logic in a way.
Yeah, roughly, again, it is a contest. Roughly, how much money are you going to spend on this race, Bob?
I'd rather not say at this point.
Yeah, Vaughn, any?
I'm anticipating probably about $5,000.
Yeah,
I think that's reasonable. The signage, advertising, just getting T-shirts and postcards and letting people know.
Yeah.
I grew up in Swanton. Obviously, I've got good recognition there and northern Franklin County. But the population centers, I've got to work hard for and make sure they know who I am. And as my opponent was saying, it is elected. It is part of the Constitution. It really is the last people's court where the people have a say and have access to it. 80 to 90% of our people that appear in probate court are appearing as pro se, unrepresented parties. And it's really a forum where they can get the services of the probate court directly from their election. The Republican and Democrat situation, as I said, there are some positions that are nonpartisan, and I think this should be one of them, but we deal with the cards that were dealt.
Bob, most important, again, I don't think a lot of people have a lot of feel for what the probate court judge is dealing with. I mean, adoptions, guardianships, to take a lot of issues.
Well, I think the main thing that the probate court does is estates of deceased persons, people that die with a will or without a will, and there's a very extensive procedure when that happens. A person has to be appointed as the executor or the administrator to manage the estate, and sometimes that's contested. There has to be the payment of debts with the court approval, notices. And I don't think that you want me to go into detail on the probate court procedure.
Probably not a lot of detail.
But that's one of the main things that the probate court is responsible for, overseeing that the people in charge of estates are doing a proper job in terms of collecting the assets, paying the bills, making sure that the beneficiaries are taken care of, and things of that nature. And of course, the probate court also does adoptions, which also require extensive work and oversight, that either step-parent or near relative or someone else is the proper person to be adopting someone. Then you also have guardianships, sometimes of minors, and quite often of adults who might be disabled. So a relative, a child, may seek to become a guardian of a disabled parent, in which case there are rights of both sides, including of the parent. And the court likes to only give as many guardianship rights as necessary. In other words, it might be strictly a financial guardianship, or it might be a more complete guardianship. So the court gets involved and tries to help people. As Vaughn said, the probate court is mostly people come in that don't have an attorney. So not totally, there's lots of attorneys involved. But the court needs to be receptive and courteous and respectful of all the folks that come on in. And I personally think that I've represented thousands of folks in Franklin County over the years, and I know a lot of them, and I know that you treat people with respect at all times. I think most of the judges in all levels in the state of Vermont do that. There used to be some judges who were very cruel, if you will, and heartless to defendants coming in. There was one gentleman in Burlington that I won't mention his name, but he was rebuked, and I think ever since then, the judges have been warned or advised to be user-friendly, so to speak, and I'm pretty sure that I would be that way, and just like Judge Bruce was and the other judges.
Vaughn, any aspect of being a probate court judge you want to kind of jump in on?
Well, I mean, it's as somebody said, most people are going to get there eventually. So whether it's through adoptions or the estate process, unfortunately, guardianships are a crucial aspect of the practice. But we also do name changes. And after 9/11, that's been particularly hard when your birth certificate doesn't match your driver's license, doesn't match your passport. That triggers all kinds of name changes. Replacement and new birth certificates. If somebody doesn't have their birth certificate or needs a new birth certificate, the probate court has jurisdiction over that. But personally, I've done work in all those areas. But we were lucky 3 years ago to adopt my daughter, and that was overseen by Judge Bruce of the probate court. So that's near and dear to my heart, because making a forever family and raising my daughter in Franklin County was why we moved back here. And so that was a really special day and really personal to me. So I look forward to overseeing adoptions and helping people make that journey that I've been on.
You might have touched on this. As a probate court, things change. Has it even, think it's evolved satisfactorily over time, Bob? I'm sure there's more emphasis on some issues now than there were 50 years ago. Is it evolving kind of a...
Well, it's getting more complex.
More complex.
The legislature just recently overhauled some of the laws, and it's about 123 pages long. Now, this isn't a complete overhaul, but it's some parts were deleted and some parts were changed and some parts are added. So it's getting more complex and more complicated and more detailed, and that's why, in my personal opinion, a full-time person is needed. But again, that is up to the voters to decide.
But again, when you, just to again go back to that point, we understand you're saying you would stop your practice if elected probate judge, but would you be pulling in? Are you saying you'd show up at court every day, 9 to 5 or something?
Yes, I mean, obviously the probate court is right on Church Street in St. Albans, and I live very close to that. I live about half a mile away, and I'm very active, and I walk all the time and run through the streets of St. Albans, and yes, I would go to the court every day and handle matters, do research, have court sessions or whatever might be required. So yes, by full-time, that's what I meant. Not that I wouldn't just have a private practice, but that I would be at the courthouse every day.
Yeah. Again, Vaughn, we covered this ground a little bit before, but you don't see that as a detriment to your ability to be a good probate court judge, that you would continue your private practice part-time, I assume?
No, and like I said, 9 out of the 14 probate judges do that, and I think it'd be a disservice to the community to discontinue my practice. I'm 47 years old. My wife works in my practice with me, and we have so many people and such a need for legal services that I can't imagine discontinuing my practice. I think it's about efficiency in dealing with the caseload that you have in an efficient manner. The revisions to the probate code that have just recently passed and come into effect July 1st, part of the reason for the revisions was to streamline some of the administration, especially for estates and guardianships, and make it easier for the probate court to keep things moving through the system. So I think those changes are going to make a difference. in terms of self-proving wills and automatic transfers or potential transfers to Superior Court. Probate court is a court of original jurisdiction for guardianships and things like that. But the appellate court for the probate court is Superior Court. So right now you have to go through the probate court process, and then the parties can appeal to the Superior Court. The new law allows for direct placement with the Superior Court if it looks like it's going to be a contested matter that's likely to be appealed anyway. It's a saving of judicial resources to just have the Superior Court deal with that right away. So that may take away some of the burden of the probate court too, and not have us do duplicate trials, because the Superior Court is a de novo review. They don't even look at what the probate court did.
They start from scratch,
Right.
basically.
And so if you anticipate that, the probate court can make a referral to the Superior Court, and that's, I think, going to be an interesting change. There's a couple of other changes with the statute that are going to be subject to interpretation, and could be very interesting how the case law develops on those, including election of spousal support and your spousal election under the estate law. They've expanded the ability to do that, and it may not be just the spouse electing that anymore. It might be other people. So we're going to have to see how that comes out. I think it might have been a little bit of a drafting error, but we'll see how that plays out. But that's the role of the probate court, to interpret the law and make decisions, and we'll see how it comes from there.
Bob, you want to jump in on anything Vaughn said there?
Yeah, I agree with you that the new laws are designed to simplify things somewhat. However, there's still a plethora, a lot, in other words, of materials and the new laws. So it will take a while to interpret them and to make sense of them all. And not too many cases, as Vaughn was mentioned, go up to the Superior Court directly, which I think Vaughn really meant the civil division of Superior Court, because the probate division, of course, is part of the Superior Court. But I think it is more complex than it used to be, and it will take a while to understand and sort out all the new statutes that are coming into effect.
There was a restructuring of the Vermont court system, maybe 6, 7, 8, 9 years ago. Was that a good restructuring, Bob, in your view, or?
I think in the long term, yes, they took all the different courts and placed them under the Superior Court umbrella. Mm-hmm. Probate court, family court, the district court. It used to be called the district court. Now it's the criminal division and the environmental division. Everything's under one umbrella now, except for the Vermont Supreme Court. Of course, they didn't want to be mixed in with the trial courts. But I think there was a little bit of confusion at first, I think. But I think now people are used to the fact that it's all one umbrella court, the Superior Court, with different divisions in it. So I think my feeling is it's worked out well in the long term.
Vaughn, thoughts on the restructuring, how that went?
I think the restructuring that went through was a positive, and making all the judges Superior Court judges, and putting everybody kind of on even footing, even though the probate judges are elected and not appointed like the remainder of the Superior Court judges. My concern is that proposed reforms, and there seems to be a movement afoot to consolidate the courts even further and remove them from the counties entirely and consolidate them in the population centers. I think the public would be enormously disserved by having to go to Burlington for all your court things, whether it's probate court or family division or the civil division. And so I would oppose further reforms in that direction, and some see the original reforms as the first step towards that streamlining of the courts and consolidation. But the Franklin Grand Isle Bar has been very active and let our views be known that we think local courts should be local courts, and you should be able to go to your county seat and get the services you need from the court system. So
I think I agree with that. I mean, St. Albans is not a big city or town or a big area, but it's such a hub of legal services and other agencies such as Office of Child Support and Department of Children and Families that it cries out to have its courts right here in Franklin County. And I agree with Vaughn that transferring everything to Burlington doesn't have the capability to do that anyway. And you probably recall...
They're pretty busy with their
and facilities-wise, I don't think they do either. And you probably recall the various strong efforts that the state has made in the past to get rid, in quotes, of Grand Isle Court. I think they came extremely close at one point.
Sounds
and when
like
the people basically rose up with torches and pitchforks to try to save, and they did save their courthouse over in Grand Isle.
Ben Joseph being, of course, one of the state reps over there, former judge, of course.
Sure.
So that's a real concern. You see that as a real concern.
It's a real concern, and it's such a concern. And I had, I grew up here, but I didn't have much interaction with the legal services community before I came back. But I've just been astounded. Many of my clients will not travel to St. Albans for legal services, even from Richford or Franklin or Enosburg, and
Just because they're just not
the distance, and they're not comfortable with it, and having legal services in a local town where you can get services, and that if they have to travel to St. Albans for their court services, they do. But so many people would go without, I'm afraid, if they did consolidate the courts, and that's one of the reasons there is no other lawyer in Enosburg, there's no lawyer in Bakersfield, there's no lawyer in Richford, and keeping my practice open is just crucial to serve.
The staff
those communities.
at the probate court, Bob, we're talking the staff there. Is it adequate staff at the Franklin County Probate Court?
I think so. There's a good staff there.
Seems like I hear very good words about the staff.
Yeah, I hear very good words about the staff, and I hope and trust they'll stay on for many years to come.
Yeah. And Judge Bruce, I can only assume you both have pretty good words for the job Judge Bruce has done. Again, kind of a veteran probate court judge at this point.
He's been around for 12 years, and as I say, he became a full-time judge. And before him, you know very well, I think, and many of the viewers know Bob Cronin, who was the judge before him. He made the same commitment, I think, when he became judge to not have a private practice, and he didn't. And so I think those folks were instrumental in my decision if I should be fortunate enough to be elected.
I realize you're governed by, laws. Any changes you'd like to see made to the probate court, whether legislature or whoever might do that? Are there any obvious changes? I realize you're not the judge at this point, Bob, but anything that kind of jumps out at you as a change you'd like to see in the functioning of the probate court?
No, not at this time, Richard. I mean, if I were fortunate enough to be the judge, I would want to talk to the present judge to see how he has done it in more detail and see what my procedure and plans would be, and maybe have some recommendations at some later point. But I think the best approach would be to wait and see, try it out, and just do it in that manner.
And Vaughn, same question. Realizing you're not sitting on the bench at this point, but any changes in the functioning of the court that kind of jump out at you from a distance?
Well, I've had, in the last 6 years, I've had 200 probate court cases, all different areas, and it's been a crucial part of my practice. Legislatively, the reforms that they've just announced are interesting. But the probate court, and this is something I've come across and had no idea, but the probate court has jurisdiction over removal of remains. And the current statute allows anybody to remove remains from any grave with mere publication in a newspaper. No notice to the parties, no notice to the families, no requirement to go to court. And if people object, then you end up in probate court. But that's one of those statutes that I don't understand, and I've contacted the legislators to say, we need to take a look at this, because this is not 1820 where nobody cares. You can't be digging up people. But the probate court has some interesting jurisdictions that people don't really think about when they think of just guardianships or adoptions.
Interesting. On that note, we're pretty much out of time. I think you've covered a lot of ground. Certainly given, I think, a lot of information to people who probably didn't have much of a clue about the functioning, perhaps, of the probate court. But I want to thank you for the time. Vaughn Comeau, an attorney from Berkshire, Bob Farrar, attorney from St. Albans City, the 2 Democratic candidates for Franklin County probate judge. Again, the primary coming up on August 14th. And again, voting is, again, we're taping the show on July 24th, voting already underway, so I'd like to think there'll somehow be at least a halfway decent turnout on August 14th. But thanks for the time, I appreciate it. Good luck.
Thanks for having us.
Thank you very much. Thanks to Zach for doing all the hard work out there. I'm Richard Cowperthwait. Thanks for watching us here on Northwest Access TV. See ya.